Thank you, Sheena, for coming here this afternoon to help us answer some of these questions about how to plan for a good death. Perhaps we could start with the very basics. Could you outline what happens to our property when we die and what that process looks like?
Well, every human society has had to grapple with how to reallocate the things and rights that its now deceased members leave behind. In Northern Ireland, every adult citizen who has the requisite capacity, what the law calls testamentary capacity, or you may have heard of sound mind, has the right to determine who takes what property on their death. They do that by making a legal instrument known as a will. You don't have to make a will. If you choose not to make a will, or for whatever reason your will's not valid, you are said to die intestate. Somebody who leaves a will dies testate. If you die intestate, your estate will be distributed in accordance with fixed and inflexible rules that are prescribed by the law. You asked about the process. Whether you die intestate or testate, someone has to take responsibility for administering your estate, for collecting in the assets, paying off the debts, and distributing the assets to the beneficiaries. They do so by way of authority from the High Court. The person in question, the umbrella term is personal representative. A personal representative appointed by a will is an executor. However, if you die intestate, there still has to be a personal representative, and in that case, the person is generally referred to as being an administrator. Another term that people sometimes hear is that a will has been proved. When a will is admitted to probate after death, it is said to have been proved.
Can you give me a summary of some of those intestacy rules?
It's actually very difficult to give a concise summary of the intestacy rules. They are designed to reflect the wishes of the average person if he or she were to make a will. They haven't been amended except in very piecemeal ways since the mid-1950s, and society has moved on bounds since then. To give one illustration, if you're living together with someone and you're not legally married to them or not in a registered civil partnership, you have no rights under the intestacy rules. It's a very sobering statistic that the majority of people in Northern Ireland die intestate, and more so, I think, when survey after survey shows that the only people who really understand the rules fully are lawyers.
So are you saying that everybody should make a will?
Generally, yes. Even people who do not have a lot of property. It's always better to be in control of who's looking after your estate when you pass on. For example, if you die intestate, which we talked about just now, and your nearest relatives are your first cousins, all of them are equally entitled to apply to be your personal representative. It's generally on the first come, first served basis. It might be the very one you don't want looking after your affairs who gets in first. In fact, often that is the case. Another myth is that it's really only elderly people who should make wills, but in my line of work, some of the most intractable disputes that I deal with have actually arisen with an untimely death of a young person who's died intestate. However, there are certain high-risk categories who most certainly should make a will. I've already mentioned cohabitants, but I mention it again because it is so important. In addition, modern blended families who have stepchildren, people who are divorced, more importantly, in fact, people who are separated but are not finally divorced, haven't got the decree absolute, people who have no close family. And what that may mean is that a lot of their estate is wasted tracing cousins around the globe. It has been said that there are two certainties in life: death, which we're talking about, and taxes. In fact, however, with the correct will, it is possible to avoid inheritance tax. So another category of person who should think about making a will are the wealthier people in society who would otherwise be paying inheritance tax. In simple terms, inheritance tax is a tax on your estate on death.
Do you have to get a solicitor to prepare your will?
No. In the first instance, you can go to a professional who is not a solicitor. In practice, that usually means a financial advisor, an accountant, and some of the banks still make wills. My own personal view, and I've no axe to grind in that I'm not a solicitor, is that it is better to go to a solicitor if you're going to go to a professional will drafter. Solicitors are supervised by the Law Society, and unfortunately whilst there's some very good professional will writers that are not solicitors, there's no consistency and a lack of regulation of that particular profession. You're also free to make your own will, whether that be on a blank piece of paper or using one of the DIY kits that you can purchase in a newsagents or off the internet. However, you do have to comply with strict formalities. Rather simplistically, this means that the will, and it is a paper copy of the will, has to be signed by the person making the will in front of two witnesses who have to be present together. In short form, all three people have to be present together. It may be worth saying that the law in England has recently changed really as an emergency measure in response to COVID. So it now is possible in England, in some circumstances, to have a virtual execution of a will using the internet when the three people aren't present in the same room. That law did not extend to Northern Ireland. Here it is still necessary to follow the old rules. To be fair, all of the DIY will kits that I examined did contain accurate instructions. The problem is people don't always follow the instructions correctly. And even if you have managed to follow the formalities and you have a valid will, the content may not be the will you want. It can be a complex enough area. And to give you a couple of basic examples, somebody might say, I leave my property to my nieces and nephews, but what do they mean by that? Do they mean simply the nieces and nephews on their side of the house, which is strictly what the legal definition is, or do they actually want to include the nieces and nephews from their husband's side of the house? Another issue that arises from time to time, somebody makes a gift of their house, but does that include also the little field that's beside the house? And so often it transpires that that little field will have development potential and actually be quite valuable. It's also really important if you have a house that's subject to a mortgage to be very accurate as to whether you want the person taking the house to be responsible for paying the mortgage or whether you want the mortgage discharged from other assets so that he gets the house free of any mortgage. So many wills I've encountered do not deal with that properly.
Well, that's another question I had. If you leave a debt, does somebody inherit your debt?
You can only leave your net estate. So if your debt exceeds your assets, you're said to die insolvent, and then it's a matter of the people who owe money, your creditors, a pecking order in relation to how much each of them is paid. If, on the other hand, there are debts, but the total amount of your assets still exceed those debts, by making a will, you can set out who actually bears the debt.
If I do decide to use a solicitor, how do I go about choosing that solicitor?
My advice is to go to a solicitor who is experienced in private client work. Perhaps the old-fashioned way of word-of-mouth recommendation is the best. However, it's important to remember that what makes a good private client solicitor, really technical knowledge, empathy and ability to communicate complex matters in a straightforward way isn't necessarily the same qualities that will have appealed to your neighbour who's had a personal injury dispute. Importantly, I think you should not let cost be the main determining factor.
Well, how much does a solicitor charge for making a will?
Well, I did a straw poll amongst various solicitors before we did this filming, and the average seems to be £150 for a relatively straightforward will without any tax planning. In addition, there are various special weeks organised. One in particular is Will Aid that people may have heard of, and it's usually the month of November, where wills are done in such a way that it's free of charge to the client, or that any contribution made by the client goes directly to a charity. And there's charities such as Cancer Research UK, for example, that works with various solicitors in Northern Ireland in order to make a will which is free of charge to the client. In addition, for those people who earn benefits or certain tax credits, the Legal Aid Green Form Scheme can extend to making a will.
So once the will is made, is it set in stone or can changes be made to it?
Your will remains in force until it is revoked, and yes, you can change your will at any time so long as you still have the capacity to do so. The burden is really on you to contact your solicitor if you've used a solicitor to inquire about changing your will, and my advice is always to review your will on a regular basis. I usually recommend that wills are reviewed every 5 years, but obviously it varies with the circumstances. Marriage will revoke a will, so if you marry after you make your will or enter into a registered civil partnership, that will revoke your will. But otherwise, in fact, life's milestones do not revoke a will. If you divorce after you make a will, the gift to your former spouse fails. But otherwise, it is very important when there's a change of circumstances to revisit your will. One matter that arises from time to time that I encounter is if somebody is terminally ill, they may well take a critical illness benefit as a lump sum. This substantially increases their assets, yet their will doesn't reflect that increase, and the result is that the will doesn't really do what they intended it to do. So it's very important that people do keep their will under review.
If I want to get rid of my will, can I not just simply tear it up?
Well, actually, if you tear up your will, if you do it personally, that does revoke your will, so long as you were intending to revoke it and not as in some of the cases where somebody was drunk and tore it up by mistake. Rather surprisingly, however, simply writing cancelled across your will does not revoke it. I know that lots of my clients complain about the cost of going to a solicitor to change their will, and over the years, unfortunately, a number of people who have taken matters into their own hands and haven't done it correctly have ended up sort of with their estates being in the middle of a very costly dispute.
Is a will about just gifting assets, or what else can a will do?
Probably the most important thing, other than the gifting of assets, is the appointment of executors. My advice is to have 2 executors, one of which is younger than you, or at least somebody you expect to be around. Executors have to work together, they have to act unanimously, so it's important that you choose 2 people who will get on, and if they're not actually getting on prior to death when you appoint them, it's highly unlikely that they will in the emotion that follows a death. If you have minor children, you can also appoint guardians for them by your will. Some people like to include burial instructions in their will. Burial instructions are very important, and in fact they're not legally binding, but my own view is that they should not be contained in a will, not least because in Northern Ireland we often bury on the 3rd day, and so many times those arrangements are already taken place before the will is even looked at. While on the subject of non-binding letters of wishes, some people want to include other material within their will, and it's understandable why they would do so. However, one word of warning: a will is a public document, and after your death anybody can look at it, and sometimes it's not maybe the best thing to have a family's dirty linen in public for the rest of time.
This might seem like a strange question, but I have a puppy Labradoodle, Milo. I'm just wondering, can I mention him in my will?
This can be a very distressing subject, and as a childless cat owner I can fully empathise. Strictly, a pet is an item of property and can be left to someone in your will. If you haven't made an informal arrangement, for example, somebody who has no close family, one suggestion may be to leave the cat or the dog to a beneficiary with a lump sum to maintain the cat and maybe give them a bit of extra. Alternatively, there are charities, including some operating here in Northern Ireland, who will arrange to rehome the pet, therefore giving quite a lot of peace of mind to the owner.
So does all of your wealth pass under your will?
By no means. In fact, with younger people where there's been a premature death, the bulk of their wealth might actually pass outside of the will. The most common example is the matrimonial home, which is often in the modern times held as a joint tenancy, and that passes to the other joint tenant by survivorship automatically and can't be overridden by will. In addition, there are death and service benefits from many employers that are written in trust and pass outside of the estate. On that point, it is very important that people keep their nominations up to date. In my experience, people are less likely to review that than they're actually likely to review their wills. And then there's other wealth, such as the most frequently encountered one in practice would be accounts with the credit union, where you can, called statutory nominations, where you can actually nominate a beneficiary to take up to the value of £10,000. So unfortunately, the will doesn't deal with all of your wealth, and it's very important that you consider those other assets as well.
Where should a will be kept?
Well, many lay people are very surprised or indeed horrified to learn that there's no compulsory registration of wills in Northern Ireland. And it's fair to say that from time to time, original wills have gone missing deliberately. If the solicitor has made your will, my advice is to leave the original in the solicitor's office and make sure you have a copy at home. If that works, sometimes there may be confidentiality reasons. I would also recommend that a copy of the will is given to your executors. If you haven't used a solicitor, and you have to store the original, unfortunately it's harder to get the banks to provide safety deposit boxes nowadays. So it is important that the will is kept in a safe place, ideally one that's watertight and fireproof.
What happens if a will can't be found after death?
Unfortunately, that does happen from time to time, perhaps because somebody has found the will and can't be located. In addition, wills can go missing by accident. You may end up dying intestate, and we've talked about that, but if it is possible to prove that your will existed, for example, if you have a copy, the probate office may be willing to accept that copy, so long as they're satisfied that it reflects the true last will.
Are there any other documents I should keep with my will?
Well, perhaps not necessarily precisely with your will, but more generally, it is very important that you leave sufficient information for those coming behind you, and perhaps in a folder. I'm thinking of a log of your various assets, including perhaps passwords for digital devices. You mentioned Milo. What about Milo's pet insurance? There's a host of various information that would be really useful for your executor to have. Whether you need to keep it in the same envelope as the will, I'm not sure that's the case, just as long as the person who needs it knows where to find it.
If I make a will, is that it? Is it watertight? Because you hear a lot of stories in the newspapers, people challenging wills.
Wills can be challenged. And it is probably fair to say that the number of challenges have increased in recent years. However, to minimise the chance of having your will challenged, it is much better to go to an experienced solicitor. There's broadly, very simply, two types of challenge. The first is by people who the law says that you have a duty to provide for beyond the grave. I'm thinking mainly of minor children and spouses, but there are others. It's a complex area, and a solicitor can advise you about that. Ultimately, it's your decision if you choose not to provide for these people, and the solicitor can advise you of the ramifications should they decide to challenge the will. The next broad type of challenge is one where the challenger says the will is not valid. Perhaps the formalities haven't been complied with. It's unlikely that's going to happen with a professionally drafted will. However, increasingly, as we become a more aged society, there are challenges on the basis that the person who made the will did not have capacity. In fact, it may be when you go to visit your solicitor about making a will that your solicitor suggests that you have a capacity assessment. Don't be offended at that. That's essentially for your protection. If you're elderly or have been seriously ill, it reduces the chances of somebody making a successful challenge.
On the subject of capacity, if I lose capacity after writing my will, is it still valid? Or can somebody change it?
Your will is still valid. The only question is whether you had capacity at the time you made it. If, however, your will has genuinely become outdated to your circumstances for the reasons that I was referring to earlier, and you've lost capacity, there is a facility for the court to make a new will for you called a statutory will, but the court will only exercise that power very sparingly, simply because your existing will has become outdated to your needs.
More generally, if I lose capacity, who looks after my financial affairs?
That depends. My recommendation, if you want to be in control of the person who will be dealing with your affairs, is that you execute what's called an enduring power of attorney. That has to be executed when you still have capacity, and there's a tendency to leave it until it's too late. So it's very important that people are aware of this relatively young, so that they can be sure that the enduring power of attorney is in place. Then when they have reason to believe that you're losing capacity, the power of attorney is registered in the High Court, and then that person can deal with all your financial affairs on your behalf. If you don't have an enduring power of attorney and somebody's needed to manage your affairs, the court will appoint someone. Someone's called a controller, but that's not necessarily the person you would have wanted.
Does that mean that that same person can decide which nursing home I go to or take end-of-life decisions?
No. Here in Northern Ireland, an enduring power of attorney is limited to your financial affairs and property. Now, it may be that you've heard something from your relatives in England about an attorney looking after their health and welfare, and the law is different there. The law may change here eventually, but currently your attorney is restricted to looking after your property and finances.
So Sheena, thank you again for this afternoon. You've given us loads of valuable information. In summary, can you tell us why it is important to people to plan for a good death?
Well, in a very narrow sense, we think in terms of a legacy being a financial gift. But more broadly, our legacy is really how we're remembered by those we leave behind. And if it's the case that we're able to leave those we leave behind, our loved ones, a relatively straightforward passage to deal with the grieving process, that is our legacy. All too often, I deal with bereft clients who are, through no fault of their own, left with a complete mess to deal with simply because their loved one didn't take the time to fill in paperwork, to make a will, to deal with things whilst there was an opportunity to do so. Death is life's only certainty. We have no idea when death will come upon us. What we can do is plan for it. By planning for it, it will give us peace of mind, and equally important, it should make the grieving process a lot easier for those who are close to us after we are no longer here.